Appeals, Division 1, is now in session.
Good afternoon. You may be seated. We are here on our case number 1, CR160336, State of Arizona versus Hernandez. So, counsel, as you know, each side's allotted 20 minutes for your argument. The appellant may reserve any amount of time you'd like to for rebuttal. If you do decide to reserve time, though, you're in charge of keeping track of it for yourself. The clock on the podium will reflect the total amount of time you have remaining, including what you might have decided to reserve. We record these proceedings, so when you approach the podium, we'd be grateful to you if you would give us your name and the name of your client.
If I may reserve 5 minutes for rebuttal. I'd like to start my argument this afternoon by saying I would like to go out in the hallway to complete my argument, and the reason I'm saying that is to make a point. The very best argument made will have no effect on this panel if the panel doesn't hear what I have to say. This is effectively what happened with Mr. Hernandez's case. A letter or letters were drafted. They were intercepted before they were given to the intended recipients. So the recipients had no way to know what action or message was to be received. As we all know, regular mail goes from the sender of the recipient in a sealed envelope to intermittent handlers who then send it along.
What if the letter had actually reached them, but they don't do anything about it? Will your argument change? So it reaches its intended audience. Let's say first it just sits there and they don't open it, but let's say they open it, but then just decide we don't like this guy, we're not doing anything he says.
It's a good question, Judge. Thank you. It has the same effect. If the letter is received by the intended recipient and not opened, the recipient still has no information on how to act or what to do. The object of
the next question, they open it and they say,
No.
We're not going to do it. We don't like this guy.
However, at that point in time, the message has been received. And then there is an action on the recipient, and that action is to decline whatever's been requested. But there is an action at that point in time.
Okay, but does the statute require more than the recipient reading the directions? Does the statute require that the recipient actually perform in accordance with the instructions or the directions or the...
I would not agree with that. I think at that point in time the statute has been completed because now there's some action on the part of the recipient, and that is to reject or decline what the person who was sending it.
But how about if they agree? I'm trying to draw a distinction. If they get the letter and they say, we don't like this guy, he's no longer part of our gang, we're not going to do what he says, as opposed to, okay, yeah, they get it and agree to do it, but then for whatever reason down the road they decide not to carry out the crimes that have been suggested. Is there a difference in those two scenarios?
I would say yes, Judge, and that is the statute contemplates that the sender of the message do something, and that is participate in this case, a criminal street gang. At that point in time, the sender has completed what the statute's requirements are. It's just that the receiving end, the receiver decides to either do something or not to do something.
So why is the distinction then? If he's dropped it in the mail, he's done everything he's going to do anyway. So why is that the distinction then? If it's just if they pick it up and read it and decide not to do something, how has the gang been organized at that point?
Because that's the verb. It's not participate. It's organize, manage, direct, supervise, or finance.
Correct, and I was going to get to that point. The state actually claimed twice in its opening brief and pointed to a transitive verb, saying that all the verbiage in the statute are transitive verbs. Well, that's a very important distinction between what is a transitive verb and what is an intransitive verb. And when we look at what transitive verbs are, transitive verbs require some action, and it requires something to be done from the receiver of the message. And if the receiver elects not to do anything, that is the action that is taken. It's the verb has a sender, an action, and an effect.
So if the crime is you're charged with organizing a street gang, and you send a communication to someone for that purpose, but the recipient says, nope, I'm not going to take your instructions. Have you successfully organized that gang?
I'll answer that with a question. If we substitute in the statute corporation for criminal street gang, it gives us a better meaning, I think, to what is actually to be done. So a person commits participating in a corporation, for example, by doing any of the following: intentionally organizing, managing, directing, supervising, financing a corporation with the intent to promote or further the objectives of the corporation. And if we look at it that way, we understand what a supervisor does, what a manager does, what an organizer does, because it makes sense to most of us. Now, when a board of directors or a panel of judges, gives some direction, it doesn't mean that the corporation has to necessarily do what the organizers and managers do, but the message has been given, it has been received, and now there is an action. It's the same as if I go out in the hallway and continue to make my argument, and the panel never hears, what action would I expect to happen? And the answer would be nothing. Using all of the words in the same way, manage, direct, furnish, and all the other language that is in the statute really boils down to the same sort of message. If you again substitute criminal street gang for the corporation, it makes more sense how we understand.
I'm not sure it does. Let's not use the corporation, because I think that's an entity. It's not individuals. A gang is not a corporate entity. A gang is a bunch of people.
True. That has leadership. It has directors. It has participants. It has a structure. There are intermediate supervisors. There are sergeants. There are lieutenants. There are captains. There's the head people who are actually directing what goes on, and there are those people who are on the very bottom level who are carrying out the criminal syndicate's objectives. So when the leaders of the criminal syndicate say, we want you to do X, and that message is received, the people at the bottom actually go out and do X. Problem is with Mr. Hernandez's case is without having that message get to its intended recipients, what participation has Mr. Hernandez actually done? Well, he hasn't actually participated, because that's an action verb that requires there to be some action on the listeners. In this case, it's exactly what didn't happen. What he did was he attempted to do something to communicate that message. That message was intercepted and was never received. That would have been a different case had the jail staff opened the letters, copied the letters, sealed the envelopes back up, and then sent it along its merry way, and then have some officers at the other end watching and waiting for those people to take some sort of action.
What's your response to? I think the state may have made this argument that organizing is a synonym for planning. If he planned something, is that it seems pretty clear that the letter evidences a plan of some sort. Why doesn't that satisfy the statute?
Well, if I do nothing other than keep a bunch of notes of things I would like to do, how to plan an event, how to do all the steps that are necessary, and nothing else happens to it, what I effectively have now is a diary. And a diary or a thought or all the intentions in the world aren't criminal. can't prosecute somebody for what is in their mind. So
I've written out a detailed plan. So and it even sets out the time that everything's going to happen. It's in the future, but I've carefully detailed a plan. Is that, if the statute read, I assume if the statute read plan a criminal event, whether there's other constitutional issues there, but if the statute just said plan a criminal event, you would agree that in this instance the letter would satisfy that?
I don't agree with that because, again, all the planning stops at the piece of paper that I have in front of me. So however detailed it may be, the best laid plans are...
But wouldn't you agree that if you're planning a party, you would say that you've planned a party even before you've sent out invitations to everyone? Isn't that a plan?
Okay. And to use that party example, if I change my mind after the very last plan and go, oh, now I have to spend how much money? And I trash that, and now I have no more plans.
But that doesn't mean you didn't plan. It just means you didn't effectuate your plan. I mean, taking it back to the text of the statute, count 1 was intentionally organizing, managing, directing, supervising. So let's take at least the first couple of these. As the state pointed out in its brief, the regular and ordinary meanings of organize and manage. A common meaning of organize is to arrange systematically, to order, to make arrangements or preparations for, and manage is to be in charge of. So if we take those common meanings and what we're looking for by the text of the statute is an intentional act to do those things, how is that not accomplished merely by the writing of the letter, whether or not it actually reaches the recipient?
Going actually from the text of the Raji, I believe, about what the definitions of an attempt are, it's basically an incompleted offense. And this is an incompleted offense. The other thing that's in the Raji is the language, a factual impossibility is not a defense to an attempted crime. So that means just because the letter never got to the recipient doesn't mean there hasn't been a crime committed, but it hasn't been a completed crime. It's been an attempted crime because it never reached where it was supposed to be. So again, all the planning for the party, for example, if it never happens, is only an attempt at trying to organize or trying to manage a party. Party never happens, it's still an attempt at doing that.
It's not an attempted plan. That would be...
It might be an attempted holding of a party or throwing a party, but it's not an attempted plan. You did the plan.
I agree. You did the plan, but you didn't complete the party. So do you have a party or do you have an attempted party?
But if the statute, as Judge Katani hypothesized, was, what was it?
Plan a criminal event.
A criminal event. Apparently his parties are more interesting.
Well, in Mr. Hernandez...
The statute is just the language of the plan of the event.
In Mr. Hernandez's case, one of the allegations was that he planned to have a crew go out and commit some crimes. And those plans were reasonably detailed, what equipment to buy, what weapons to have, and things to say, what to do if you have somebody, who's now a captive. What do you do with them? Those plans are still plans. And in Mr. Hernandez's mind, if that letter had been received and those people got the message and did what he asked them to do, then we have your situation here. But without that, the best laid plan means nothing. It means I have an intent to do something, which is exactly what the definition of the attempt statute is.
Isn't the better argument that none of these verbs means plan? The statute doesn't say plan.
Correct.
The statute says organize something. And organize means, I would suggest, act on something, not just simply make notes, but act as if to effect something on other human beings.
And it's that word effect on others that is the language that I'm focused in on. It has to have some effect on the listener. Without such, we have no completed crime. What we have is that attempt.
So it has to have, at a minimum, some response, some, not necessarily a communication back, but it has to have some response on the part of the recipient.
Even if the response is, I'm not going to do that.
Well, maybe not.
I see that my time is up for this part. If I may reserve the rest of my time for rebuttal. Thank you.
May it please the Court, Lindley Wilson, Assistant Attorney General, representing the state of Arizona in this matter. Appellant's convictions are supported by sufficient evidence. His crimes were complete when he in this case, deposited them in the jail mailing system. And I would agree actually with Judge Perkins' point that, or suggestion that merely writing the letter would satisfy the elements of the offense, but in this particular case,
Would or would not?
would satisfy the elements of the offense.
So if you,
Keep it?
yeah, if you just write some notes to yourself, does that, you've organized a criminal gang that way?
Well, in every case, the state will be required to prove intent to promote or further the objectives of the criminal street gang. So
The problem I'm having with the argument is this is different than organize an event. This is organize a criminal gang. And so if you haven't, you have to organize the gang. And I don't know how you could ever do that without the gang actually hearing from you or getting
I think
involved in some way.
the biggest point in this case is that the legislature was purposeful about its use of all of these different verbs and organizing. The court actually beat me to the birthday party analogy, but when you are assembling a list of people to invite to a party and even buying decorations, all of that is organizing in a commonly understood meaning of that term.
Well, but you are buying the decorations.
Just as the defendant here was writing the very detailed instructions on a piece of paper.
The object of the verb is what's key, and the party, organizing the party, is not the same as organizing people. How can you organize people if they don't know that there is even an attempt to organize them?
The object is the criminal street gang here, and I appreciate the corporation analogy, but of course here the legislature was intending to criminalize conduct of criminal street gangs, and so I think where there are these reasonable interpretations of either meanings of these terms, we need to look at legislative history and the overall context of the statute.
They're still criminalizing, even if it's an attempt. It's still a pretty significant, serious crime. But a more serious crime has been averted, thankfully, which trying to figure out how it's different if someone is trying to shoot the president and the Secret Service steps in and pushes them aside. It's an attempted murder there. They tried to murder the person, but it was pushed. They were pushed away, and so you don't have a murder. But so why is this different? You were trying to organize this gang, but before you got to it, before you were able to do it, someone got in between, and the gang wasn't organized to do this.
I think the critical difference here is that the legislature specifically intended to criminalize this precise conduct. It wanted to cut off gang activity and involvement before it even had another effect or
Well, it's before
caused
it
another.
commits crimes.
Right.
But we try to prevent murders too, but we...
And interestingly, with the murder analogy, the legislature has chosen to write there that the person causes the death of another person. So it's not causing the death. It's not in the process of causing that death. It's the actual result there. To be convicted of murder, you, of course, have to cause the death of another person. And if it's an attempted murder, that means in that instance you were not successful in your in what you were aiming to do.
Take me back a step then. You're saying you would have organized a criminal gang if you just write things down. It's in your journal. That's the first step. The next step is going to be you're going to have it typed up, and you're going to send a text to someone. But you've started with just some notes to yourself in a journal. Have you organized a gang?
I think if the state can prove you had intent to promote or further that's always going to be difficult for the state to prove the journal entry case, and this is certainly not that case. But and that might be a closer question. But
well, how about if you've just had the thought in your head and you might have mentioned it to a friend? Is that going to? Is that going to satisfy the statute?
I mean, the thought in your head cannot be, that would be hard to,
Now, how's that
would not
different
be
from-
criminalized.
I don't think you want to go here. That raises a whole bunch of due process issues.
Well, in State versus McCoy, this court held that this particular statute does not criminalize protected speech when the intent is proven to further assist a criminal street gang. I also quickly would just like to take issue with the idea that he did not meaningfully or actively participate in the gang by what he did here. He's using the jail's resources to accomplish his task, and I think, as Judge Katani mentioned earlier, everything he needed to do was complete when he wrote this down, marked it as legal mail, and then put it in the jail's mailing system and caused jail resources to be diverted to tracking down these. So it is still meaningful and active participation, even though, again, participation
Did he
is not
organize
even.
the gang, though? Was the gang organized?
Yeah, what you're saying is that the subject of the verb completed his part,
Or
but
the
there's
sh-
still the object.
the-
There's still
The shooter pulled the trigger.
I think this is, again, just different than a murder example or other parts of the criminal code because the legislature did not say organized a gang, which might contemplate
Isn't
some
that part of it?
completed action. It's organizing. It's,
See, it seems like your point in terms of the legislative history is the legislature concluded that the existence of gangs is a bad thing, whether or not and gangs are defined kind of oddly in the statute by what they do, but separate and apart from what they do, the existence of a gang is a bad thing. Doesn't that mean that you have to interpret the statute organizing a gang to mean that a gang has been organized by your conduct?
I think that is reading too much into the statute. And if there's some ambiguity about that, again, the legislative history is showing that that by enacting this particular statute, the legislature wanted to cut off gang activity before it caused other harm.
But that's really
couldn't that be
that just goes around in circles. The existence of what you're saying is the existence of a gang is a bad thing.
No, I'm not saying that. I'm saying the scope of the statute's reach encompasses this defendant's conduct. He is engaging in these verbs used in the statute when he.
Isn't he just attempting to organize them? And we can criminalize that conduct if he hasn't.
I think if we reduce these convictions to attempt, that would frustrate legislative intent. If another important.
I'm sorry. Before you go there, could you address why the logic in Gray should not be applied here? The inducement.
Well, there again, the legislature said induces a witness. So it's not inducing a witness, which I think is a distinction. And I think Gray recognizes that you can induce.
Doesn't Gray say that there has to be someone has to act on it? They have to be induced into doing something as opposed to just receiving and saying, "I'm not going to do that."
Gray ultimately takes the definition of induce that I do not think is applicable here. So the definition of inducing for purposes of this statute in consideration of its context in the legislative history is that along with the words incite, it is prescribing conduct that is prevailing upon another to take action. Here the defendant's letters were had actual people that these instructions were addressed to. And so it's I like the Gray case because I think it establishes a statutory framework to follow and that there are these competing definitions of induce, but I think the opposite result should be compelled in this case.
But
And
isn't this case a little bit more challenging for the state with organize? Seems like you have to have, if you organize the socks in your drawer, I mean you've had to do something, and if they're not organized, you haven't organized. You can't just be thinking about it. Organized suggests that something will happen.
Like the birthday party example, again, you're still organizing a birthday party even before you've invited other people or certainly before they've accepted your invitation. You're still in the process of organizing that event.
Organizing a party as opposed to organizing people.
Sure, but again, the commonly understood definition of this is to plan and engage and do preparations for. And
No. We have to look at the words in the statute.
absolutely.
And I just don't buy that when you write down a checklist and don't share it with anything, you've organized. a gang.
I think that's requiring too much under the statute. And a point that maybe helps with looking at the context of the statute is subsection B that talks about assisting a criminal street gang. And it says you are guilty of this offense if you engage in conduct, whether preparatory or completed. And I think that actually helps and supports the state's argument here because it shows a legislative intent to encompass preparatory conduct. So even if this could be, in the colloquial sense, thought of as an attempted crime, or it might, it has that maybe gut reaction that, oh, this really sounds like more like an attempted crime. I think the legislature's inclusion of preparatory offenses in subsection B.
But isn't that you're assisting without, you can assist them without any gang member knowing. You can do a lot of things that might assist.
Right. It is in some ways easier to establish
than saying a crime that involves you organizing the gang members to do something. Well,
I agree that it's easier to establish assisting a criminal street gang, but it in some ways I think shows that the legislature's already built in assisting a criminal street gang as a lesser offense that's not as serious as participating.
But you've actually accomplished something. You've done something to assist. That seems different than I'm trying to organize this group, but they received the letter and they say you're not part of us anymore. We don't want anything to do with you. In that circumstance, has anything been organized? If they receive the letter and they say, no, we are absolutely not going to do that. I'm having a hard time finding out that is any different than Gray.
Well, I think what you first pointed out, you were talking about assisting a criminal street gang and that requires some effect. But it actually is by committing any felony offense, whether completed or preparatory.
But that statute that turns it around. The actor is acting at the direction of a gang, so it's really not.
And it is a different. Obviously there are no convictions here at issue with respect to subsection B. But I think if you're reading the statute as a whole, it supports an argument that even if this type of conduct could be considered as preparatory in any way, that is what the legislature intended to criminalize with subsection A. It wanted to move up the timeline.
Why didn't they include that language in subsection A as well?
Because A is actually establishing the substantive offense. A is listing out exactly what this crime is. B really relies on other predicate felony offenses, much like felony murder or something, in order to establish what assisting a criminal street gang is. But A lays out the elements of each offense, and again, just in context and in light of the legislative history showing that the intent was to cut off gang activity as soon as possible. And in fact, they remarked that prison gangs in particular were a very serious threat to Arizona, and that these other states who may have similar gang provisions, that their laws maybe didn't go far enough because
doesn't the mere fact that we have the statute, doesn't that discourage people if they do something and they actually organize a gang, it's something that's going to be criminalized? I'm not sure I'm accepting that we're somehow not giving any deference to legislative intent by saying this is an attempted crime, but he didn't succeed in organizing them to actually carry out to do something to commit another crime.
I think each subsection of the statute certainly needs to be evaluated on its plain meaning, and to the extent that there's ambiguity, that, again, the legislative history and context just answers the question. So, if...
This seems very close to Gray, because there was clearly an attempt to induce someone, but the person who received the letter just said, no, I'm not going to do that. And the court said, okay, that person was not induced because they didn't actually, there wasn't a completed inducement. It seems like here we don't have a completed organization.
And the court's conclusion in Gray was supported by the legislative history and overall context of the statute. And again, that language says knowingly induces a witness. And so,
wouldn't the legislative history not somehow encourage someone to send the letter that was sent in Gray? And just assuming that if somebody doesn't act on it, then it's not a bad thing. It seems to me that the legislature doesn't want somebody to send the type of letter that was sent in Gray, just like they don't want someone to try to organize a gang. But it doesn't change the fact that the court simply found that it was an attempted inducement in Gray.
Right. And again, the statute in Gray is not penalizing conduct by criminal street gangs, so it's just the Gray framework, I think, is helpful for this issue, but it is an entirely different statute with a different purpose underlying it, and so I don't think it's that close to the result in Gray.
You know, Judge Catani was asking a hypothetical about what would happen if this letter actually did reach a recipient, but the recipient said, "No, I'm following someone else now. You're no longer my leader. I'm going to go with someone else." The state's position would be that that's a completed offense.
Absolutely, but I think that's part of the danger of reading the statute in that manner of requiring a cause and effect, because that's always going to be very difficult to prove, and that would certainly frustrate legislative intent if now there has to be some conduct caused or some ultimate result of the defendant's conduct, then the harm has already occurred that the legislature was intending to prevent here.
Well, but I'm seeing a difference between the crime being carried out. Let's say they get it and they say, we're going to do that. We are going to go out and commit these crimes. But then for some reason down the road, they don't do it. I can see that they've been organized, but something else may have kept them from committing the crimes that have been outlined. But that seems different to me than them getting the letter and saying, no, we don't want anything to do with this person. We are not going to organize and do anything. So it seems to me organization has not occurred in that scenario, whereas if they get it and everybody agrees, but something down the road thwarts their further criminal activity, he would still be guilty of organizing a criminal gang.
So in your hypothetical where they say they're not going to do whatever he instructed them to do, are you suggesting that would still be an attempted offense?
That would be an attempted if no organization occurred. I'm trying to understand why that's not logical. If that's the conclusion, then anytime another defendant does this type of conduct and uses the jail resources to mail out these very alarming letters to gang members, it will always be an attempt, because in many cases it will be very hard to prove that there was actually an effect or something caused that, or that his efforts were successful. For example, here, this home invasion. It's going to be very difficult to ever show that this home invasion took place and it was a result of this defendant in jail telling them to do that. So that I do think that would frustrate legislative intent. But what I'm getting at is I think you can organize if people just receive the letter and there's absent some indication that they're no longer working together in any way.
I think that's too fine of a line to draw, because the plain language of the statute does not require any effect or result of the defendant's conduct. So I do think that would be reading into the statute a requirement that not only does he engage in one of these acts, but it has to affect somebody else.
If you were to write the statute as an attempt statute, let's say there were two statutes, this one for the actual commission and there was another one for it, how would you write it? What would you say?
I think the legislature's encompassed all of that here.
No. My question is, say the legislature wanted to criminalize an attempt to do these things. My point is, how would it be written any differently?
Maybe subsection B helps that answer, because if you look at subsection B, which is again directed at gangs and has this general same purpose underlying the whole statute, they're relying on other substantive provisions in the criminal code for the underlying felony, and then saying whether this is completed or preparatory, you're guilty of assisting a criminal street gang. And so in subsection A, they're listing the offense out in very specific terms, which I think is written very broadly to encompass a lot of conduct. And I think that is evidencing a legislative intent to encompass anything that could be thought of as an attempt, maybe in the ordinary sense. Maybe a helpful analogy is also burglary. If you enter or remain unlawfully on property with intent to commit a theft therein, your offense is complete at that moment. Regardless of, maybe in the colloquial or ordinary sense, someone might think, well, burglary requires you to take something or do something more.
Burglary is defined as entry with an intent to do something.
Right. Entering or remaining unlawfully.
Could I ask a different question?
Sure.
I know you're running out of time, but what, in your view, would be an attempted? If you would agree that there could be a crime of attempted participating in criminal street gang, I assume. What in your view would constitute attempted participation in a street gang?
I think, maybe, and again, this would be a very rare case. This is probably never going to happen, but if a defendant tells, we could take the same setting here as a jail, tells a cellmate across the hall, I'm going to write this letter for the Arizona Mexican Mafia and I want to cause this home invasion, I want to further promote, further
Saying
promote.
I'm going to do something?
I'm going to do it, and here I'm going to begin to write it down, and then someone knocks the pen out of his hand. That might be an attempt. I think that's an analogy there. And he's taking a step further, putting pen to paper, but all the other elements of the statute are satisfied, and that's what the legislature intended here. I see I am out of time. I appreciate the court.
So he would, but once he writes 2 sentences that include instructions, that's the crime.
That identify, assuming all the statutory elements are met, that criminal street gang can be established, and that one of those verbs is satisfied.
But you're saying that would just be an attempt?
No,
just written.
I think the 2 sentences example is a completed crime.
So it's only when he just says, "I'm going to do this."
Well, I was trying to come up with a hypothetical for an attempt where it's he's believing
pen is
that
out of ink.
Yeah, something like that. The last thing I would like to encourage the court to do is, by no means does the state think that all of these convictions rise and fall together. So, to the extent there may be concerns about any of these convictions, I would just encourage the court to interpret each provision of the statute according to its plain language. Thank you.
Thank you.
To answer one of the questions, what happens if...
Excuse me. Thank you.
What happens if a person plans to and actually goes out and shoots somebody and kills them? We call that a murder. But if somebody goes out and plans something and shoots them in the leg and the victim survives, what do we call that? We call that an attempted murder. There is no difference between that case and Mr. Hernandez's case. The definitions of organize and induce include more than just one definition. So to organize is not only to arrange systematically or order, but it's to coordinate the activities of such as a person or a group to do it efficiently, or to form a number of people into doing something. Inducing, the definition is to succeed in persuading or leading someone to do something. And it's that word succeed that makes that action have to happen.
Is induce different than organize, if that's part of induce?
Correct. I think that in inducing, you're doing a little more because that actually anticipates there be a completed action.
But so you're saying there's not a completed action with organize?
Well, I don't think in this statute. I think you can organize your socks, but you still have to do something. You still have to move them around. Haven't
you organized once something is done? If somebody has received your letter and they've said, okay, we'll do this, even before they go out and do, haven't you at least, hasn't the organization occurred? You still have organization, but if you are to induce, you have to succeed in the organization. So I think they're slightly different. The other thing that is interesting is referring to subsection B of the statute. Subsection B actually requires committing a felony offense, which subsection A does not. Subsection B also contemplates a preparatory action of some kind. In other words, they've already written the attempt into the statute. That's why it's a Class 3 felony instead of a Class 2 felony. And preparatory is still a felony, an offense, is that? It is, but it's a lower class felony, as if an attempted participation is a Class 3 felony instead of a Class 2 felony. So subsection B already anticipates that attempt being in there. I don't think there's any difference in
should be any difference in how to write the attempt statute. I think it's been written very well, actually, and it says whatever it needs to say, and that is it's an incomplete crime, whether it's an incomplete murder, whether it's an incomplete robbery, whether it's an incomplete anything. In Mr. Hernandez's case, it's an incomplete organization. He didn't organize anything. All he did was organize his thoughts, and again, you can't criminalize him organizing thoughts. So in order for participating in criminal street gang to be complete, that organization has to have some action on the other end. I disagree with the state that the object is the gang. That's the indirect object, but the direct object is the action itself. Do something. Go out and kill somebody. Go out and rob somebody. Go down, burn a building down.
I thought the object was you have to organize the gang.
Still have to organize, but organizing your thoughts either in your mind or on paper is no different. It's still an incompleted set of actions. It's just an attempt to do something at that point in time because the organization is incomplete. No different than if I'm organizing my sock drawer or anything else. I think that's all the argument that I have at this time, and I'm happy to answer any questions from my remaining time.
What is the remedy that you are asking for?
The remedy that prior counsel was asking for is to reduce the offenses to an attempt across the board on all three of the accounts. I can't really argue against her. I would have argued, I would have argued this a little bit different. But I think this court has that ability and has the authority to do that. And I don't think it's an improper result to reduce this to an attempt and leave it at that. I think the greater ramification is to what do we do with those cases that are pending or in court or the future. I think that's what really we need to, for the future, to focus in on, not just Mr. Hernandez's case, because if this court decides that what has happened in this case is an attempt, now we have a new case that's going to probably be applicable to all future cases, which then will probably get people to prepare their cases differently.
Are you suggesting that we need to do something about that?
I'm suggesting it's not a bad idea to address it.
Isn't that what happens when we issue decisions?
It is, when there's an opinion, when there's a published opinion. I would agree.
Just to clarify, are you suggesting that we have the authority to amend the convictions
Yes.
and call it a day, or would we need to remand for resentencing if we went that route?
I forget the number of the statute. It was cited by the state in its brief. I think this court has the authority to amend the convictions to an attempt because it's effectively a lesser included offense and not have to remand. I don't think a remand is necessarily a bad thing either, but I think this court has the authority to do one or the other.
But Judge Perkins was asking about resentencing.
Correct. Oh, my apologies. Yes, I think at that point in time we have to go back because now they're different class felonies and the resulting sentences are probably going to have to be reduced by law. I don't think that even the attempt could stand with the sentence that's currently imposed.
All right. Thank you.
Thank you, judges.
Thank you for your argument and for your briefing. We'll take the matter under advisement and issue a decision in due course. Now we'll adjourn.